Hi everyone, my name is Delene Grant and welcome to part 12 of my presentation on Ontario Superior Court of Justice Motion Record and Order. All right, we're getting there. Just one more to go. All right, one more to go. Please bear with me. We're getting somewhere. We're now at 2022, the Canadian justice system. All right. May 2022, so a year later. Criminal activity number 25, they're all scattered all over the presentation. As I did make mention, I had them like in order. It was too long, so now I have separated. So sorry, I just leave it as is. Okay, but just to show you that there are so many criminal acts, and this is criminal act number 25. Motion filed against me at the Ontario Superior Court of Justice by the following entities. Okay, Bell Mobility Inc., Money Life Insurance Inc., and Industrial Alliance and Financial Services Inc., and Bell Mobility Inc. Then another one, Industrial Alliance and Financial Services Inc. You notice these two combined, and then this is separate, eh? And Hicks Morley Law Firm, Bell Mobility's lawyer. All right. Ontario Superior Court of Justice motion. I'm being sued by the following entities. What a joke. This was what the Ontario Superior Court of Justice accepted, eh? Accepted all these confusion. All right. So one, my life insurance company, Industrial Alliance, and Bell Mobility using the false combined statement of claim. And you notice the file number says it ends with 2786. This is the false statement, the combined statement which the Superior Court also used. Okay? It's used interchangeably, right? Then two, you also saw Industrial Alliance Insurance, right? Was there a separate statement of claim specifically for this company? What were the details? If combined, why separate now? Right? And as you can see, it still says 2786. And you can recall, these two were used interchangeably. All right? Okay. 3. Mobility Inc. Are these lawyers or court confused? They included Mobility above with court file number 2786. As you can see, Mobility is here too, 2786, right? But went ahead again and used the statement of claim Mobility created by Sanfaruto Marking Law with court file number 0202. See the confusion? Hicks Morley Law Firm, I must pay this firm for their criminal acts against me, which included the motor vehicle accidents. Yes, I am calling Hussein Moffederi out as he left trails of deceit in 2019. Yes, on the motor vehicle accident. He was one of many others. I am not judging. I am a child of God. I'm dealing with evidences. All right? Trail. He has left trail, and I was able to follow that. Yeah, they were negligent. They thought they were good. They were slick. As I said, I'm a child of God. God of all seen eyes, and allow me to see. Yeah. All right. Please feel free to continue viewing this deception, and for me to pay these lawyers for their acts, their criminal acts against me. Okay. After the deception of the entities, I must pay legal fees of $20,000 or else. And I put in quotations. Immediate steps will be taken to enforce the order pursuant to R.60.02 (1) Rules of Civil Procedure. They are lawbreakers and they love to use the same rules of civil procedure, but they're using it on me, eh? They're the only ones to break the law. Okay. This is part of, I did include this in my presentation on denied by all entities. All right. However, this belongs to this part of the presentation. So I have here denied 21. Ontario Superior Court of Justice. One, Name-Mark Law submitted false statement of claim provided by Nickel Law, Remoney Life Insurance and Industrial Alliance to the court. Name-Mark Law took the wrongful dismissal claim, Mobility from Sanford to Markin Law, and did nothing for 2 years, then decided to dismiss my claim. Name-Mark Law and Nickel Law then submitted a combined statement of claim for Money Life Insurance, Industrial Alliance, and Mobility to the court to further complicate my cases. There were no details provided in the statement of claim on the reasons why Industrial Alliance long-term disability was liable. The Ontario Superior Court of Justice ordered that I pay these lawyers who misrepresented my cases and these entities that discriminated against me a total of $20,000. Name-Mark Law had never submitted statements of claim to the Ontario Superior Court of Justice for my 2 rear-ended motor vehicle accident claims. 2 years later, 2021, Name-Mark Law dismissed my cases as if they did not occur. Nickel Law Firm Deception, Hicks Morley Law Firm, Bell Mobility's Lawyer Deception, and Name-Mark Law Deception had it all wrong. Statements of claim should have been for 3 entities as per below. I'm stressing on it, eh? I'm stressing on it. Important. Because I know I have common sense to know definitely that there are 3 different entities and I'm suing them for separate damages, okay? Mobility Inc., 1, wrongful dismissal, May 24, 2018. My life insurance company for short-term disability, I'm saying it again, May 2nd, 2018 to May 1st, 2018, and for damages. And I also include in October 27 to present. There's a reason, okay. Industrial Alliance Insurance long-term disability, May 2nd, 2018 to present, okay. Okay. As you can recall, regarding item number 3 and 4 below, item number 4 was involved in the statement. I was involved. Let me here 3 and 4. 3 and 4, long-term disability and wrongful dismissal. It says here, item number 4, I was involved in a statement of claim for wrongful dismissal, right? That's number 4, I was. With Sanford to Markin Law. Therefore, my termination date is correct. Name-Mark Law had done nothing to my claim since retrieved in September 2019 after I retained their firm on July 26, 2019. Item number 3, which is long-term disability, okay? If I was involved in the creation of a statement of claim long-term disability, I would have informed the lawyer. 1, I was suing Money Life Insurance for short-term disability, right? And everything's as I already pointed out before, and I was suing Industrial Alliance for long-term disability. Okay. It says here from Denise Coy, on February 18, 2021 at 3:21 p.m. Please see attached letter. And this attached letter, when I open it, this is what I get, the PDF. Name-Mark Law. Okay. I was actually informed by the Ontario Superior Court to pay a total of amount of $20,000 to the following entities for false claims that were filed in the court of law on my behalf by the lawyers without my knowledge or involvement. Industrial Alliance Insurance and Financial Services Inc. and Mobility Inc. payment in the amount of $15,000 for cost of motion and for preparation of trial, right? Manufacturers Life Insurance Company payment in the amount of $500 for work on this motion and attendance at court. X Morley Law, Bailability's defense lawyer, I am to pay lawyer's fee in the amount of 4,500. Sorry about that. Be free to review. That's how we got that. We came to the 20,000. All right. Here it says again from Ontario Superior Court of Justice. The combined order here, combined again, delaying grant, and it says here, feel free to read. Okay, I guess this was the 15,500. All right, it says here 13,000, and it says here 500 and 2,000, as you can see here. Let me enlarge it. So 2,000, 13,000, and 500 give you 15,500. If this was a combined order, why wasn't Industrial Alliance Insurance or Bailability mentioned? Why is only Manulife mentioned? Okay, and X Morley Law. Why, if it was a combined order? Question. Anyone can answer that? I thought this was a combined order. Industrial Alliance and Mobility Inc. are missing below because you can see this says manufacturer's life. Eh? This is the same combined order, but only Manulife Insurance was mentioned on the last page. Was this motion certified? Okay. On May 2nd, 2022, received letter from X Morley Law asking for payment of $15,000 or else. This letter was so misleading since there was no separate file for Industrial Alliance, which was the subject of their request. In the body of the letter, it stated, please provide a check in the sum of $15,000 representing costs awarded to Industrial Alliance and Mobility for both the motion and action. Are these lawyers confused? This information is different from the court order from the Superior Court in 2021. So, Karen and Thompson, okay, of X Morley Law, sent this to me. Okay, attachments. It says here, May 2nd, 2022. Please see the attached correspondence from Miss Amy Tibble, together with enclosure, both of which are hereby served upon you pursuant of the rules of civil procedure. All right. So the letter for payment, and that's the letter. Order by Justice Dennison. Okay. There was no mention of Manulife Insurance within this letter. That's okay, since the court ordered that they should receive $500. Okay. So here is telling me that I should pay $15,000. 2,000, 13,000. Okay. And Manulife I should pay Manulife 500, but it was not mentioned. Okay. So you needed $15,000 from me. So Manulife wasn't mentioned or on that other letter, but here now it shows here Mobility Inc. different order, but wasn't Mobility on that other order on the other slide? Okay, you see the confusion here, and it's saying here that I should pay the lawyer. This court further orders that the plaintiff pay the defendant, okay, costs for the within motion and action in the amount of 4,500 made payable to X Morley Law, Hamilton Story LLP in trust within 60 days. So I stated here, if there was a previous order which combined all entities including Mobility, why did I receive a separate order for Mobility in October 2021? X Morley Law was aware that Sam Markin Law had computed a statement of claim, wrongful dismissal in May 2019. Therefore, filed a separate motion to have it removed from the court system. What did the law firm do? I had to pay for it, I was ordered by the Superior Court to pay X Morley Law the amount of 4,500 for costs for the within motion and action rebuild mobility. Okay, please feel free to review. Thank you. Mobility Inc. So from Karen, okay, another letter, May 2nd, Monday, May 2nd at 8:39 a.m. Okay, May 2nd, 2022. Okay. It stated here, all letter repayment. Okay, this was Bell Mobility now, eh? I can see, I know the number, file number. And as you can see, it's from Hicks Morley Law, May 2nd, 22. And it says Dell Lane Grant versus Bell Mobility Inc. And it says here that I should pay 4,500. Please feel free to read. Okay, thank you. And if I did not get the check, if they didn't get the check by 5 p.m. on Saturday, July 2nd, 2022, I thought business is 9 to from Monday to Friday. Why was Saturday included? Was it because of the date of July 2nd? Is July 2nd important? July 2nd was the anniversary for my motor vehicle accident. All right? Okay. If anyone knows something, can say. I just find it strange that they gave me until Saturday, July 2nd, 2022. Please feel free to pause and read, okay? Below was the order for May 12, 2021, Rebel Mobility Inc. Court file. Okay, for Bell Mobility. That's it. Remember, I brought this forward because they did say there'll be no costs. Remember that. So I brought this forward. The order said there'll be no costs, but yet still the motions is saying I should pay. Okay. Statement of claim, wrongful dismissal, summary to mark in law. See details in previous presentation. This was the only statement of claim that I reviewed and signed with lawyer David Vaughn, as you all aware. I've also received a statement of defense, as you all aware. So far, neighbor Claude piggybacked on the other law firms, as you're all aware. Since May 2019, Hicks Morley Law and Nickelodeon Law tried to disannul the wrongful dismissal case. They have been trying, right? That's why they confuse it so. I'll read it again. Since May 2019, Hicks Morley Law and Nickelodeon Law tried to disannul the wrongful dismissal case within the court of law by faulty state in duplication. They finally succeeded in its rejection in May 2021. Okay. As you can recall, this is from Hicks Morley Law. Okay. And I assisted. Addressing correct and address is correct, sorry, and company name correct. Everything's good. Everything's good. Certified and everything dated. I was ordered by Hicks Morley Law firm to make payment of $20,000 by July 2nd, 2022. I was then threatened that if I failed to meet the deadline, court, immediate steps will be taken to enforce the order pursuant to R.60.02 bracket 1 rules of civil procedure. This meant that they would retrieve payment from any property that I owned. The only property that I was left with after I was stripped by this country was my house. Are these deceitful lawyers actually saying that they took payment from my house? If so, there's no lien on my house. Huh? Okay. As you can see, the 60.02 bracket 1, it says in addition to any other method of enforcement provided by law and order for the payment of recovery of money may be enforced by a writ of seizure and sale from open bracket, close bracket, Form 60A under Rule 60.07. You talk about garnishment under Rule 60.08, a writ of sequestration, if that's a pronunciation, caught off guard there, for Form 60B under Rule 60.09, and feel free to pause and read. I'm not going to go through all this. If you wish to, please feel free to pause and read. Writ of seizure and sale. Where an order may be enforced by a writ of seizure and sale, the creditor is entitled to issue one or more writs of seizure and sale. Please feel free to pause and read. I'm going to go to the next slide, okay? Feel free to pause and read. Talk about garnishment here. Okay, 60.08. A creditor under an order for the payment or recovery of money may enforce it by garnishment of debts payable to the debtor by other person. And you talk about joint debts garnishable where leave required. Obtaining notice of garnishment. Please feel free to read. Okay. Please feel free to read. You'll find it interesting, okay? Please feel free to read. That's why I was thinking that my house, in other words, I guess there's a lien on my house, so how would they get the money, right? Okay, they have not asked me, they have not called me or anything, so they must have got settlement somewhere, okay? So here, it says here, the writ of sequestration leave required, 60.09 bracket 1. A writ of sequestration, form 60B, directing a sheriff to take possession of and hold the property of a person against whom an order has been made, and to collect and hold any income from the property until the person complies with the order, may be issued only with leave of the court obtained on motion. All right. So when I look up lien on your home or your car or any other assets you have in your name, are going to affect your credit score negatively. Please feel free to review. Thank you. I do not owe these entities any payment. I ignored the charges. Request to have these false claims against me removed from the justice system. Okay? I had brought this one forward again for you. So I've already done a presentation on it within the motor vehicle accident presentation, right? However, I brought it forward because this was the same year, 2022, when my accident injury came back. The pain came with a vengeance. You understand? The same year, the court and these lawyers are telling me to pay. You see, they allow the system to ignore my injury and ignore the car accidents and all that, and they're telling me to pay them, even to put a lien on my property. You understand? I was really injured. You understand? So just letting you know that during the time the lawyers were suing me, I was not been taken care of. I still had my injury. They left me to suffer. That's what they wanted me to suffer. So although I was in pain and still have my injury from my workplace and then motor vehicle accident injury, they didn't care less. They just wanted me to suffer. How dare me come up, have so much evidence on them? Or am I? Eh? In other words, that's what they're actually, to me, that's what they're actually saying. So they make sure that they are going to silence me by any means necessary. So I should suffer. Okay? And I'm going to show another, that's the last slide. Okay? The last slide here, March 8, 2018, with my hand. I did a video, that's why I know it was March 8. Okay, I did a video, and this is a snapshot from my video. I already showed this to you also, that I still had my injury. All right, terminated from my work on May 24, 2018. This is what my hand had looked like. I did a snapshot from the video so I can show you. Okay, and then December 14, 2022, yeah, I was still in pain and all that. And as you can see, same year, still 14 December 2022, when these lawyers were on court, went all out on me, WSIB and everyone. I tell you, the system shut me down. Okay, and January 28, 2023, I'm showing you here, took pictures with my girlfriends basically, and just showing you, it's a few of us, but I was close to one of my friend here, and I'm showing you that the hand, you notice her hand has a curve, eh? Her hand has the curve. Yeah, her hand is fine, right? But as you can look at mine, mine is still swollen. This is from what the front angle, the front view, I should say. Front view, right? This is what it looks like. My hand is still swollen. Okay, and this is a side view of my hand. You can see the swelling, so you can know that this, my hand is still swollen. All right, 2023. So you must understand that, yeah, they and I'm denied by CPP disability. Remember, my co-worker who didn't, her hand has no swelling, eh? But anyway, I guess to teach me a lesson, they approved her CPP disability. They approve her WSIB, then afterwards they approve her CPP disability and denied me. You understand? And it's obvious that something is wrong with my hand. Unless Rose say, right, my past co-worker, right? Unless she said, I have an injury, you can't tell because it's not obvious. Mine is obvious. Okay, and I'm in pain. Yeah, no, and again, I have to be careful. I have to be careful, right? So yeah, the system here left me to suffer. No money coming in, nothing. Only God is keeping me, I tell you. Yeah, nothing from 2018. Yeah, please feel free to review. Thank you much. Thank you for your time. Thank you.